So I'm going to start reading questions, and so the first question came in: is there any way someone can be referred to me? The answer is it's very challenging at the moment. So many of you know, and if you look at my webpage, I try to keep people updated. I have a long waiting list. And I have decided to take a sabbatical this fall. So that is going to bring the waiting list to a standstill. And so the short answer is it's theoretically possible, but practically not that possible, at least for the next year or so. Someone asked, should you apply for CPP and Hr or just Hr? My understanding, and John, go ahead.
If you apply for Hr, you are required to apply for CPP. Is this mic on?
Yes.
Okay, there's a requirement that's they're somewhat flexible about, but it is on the form that says you should apply.
And it's good to be on both, because if you're just on CPP, you don't get medical benefits. But if you're on Hr, you get medical benefits. That can make a huge difference for some people.
And on the other hand, if you are on CPP as well as Hr, then that is a benefit when you reach 65 and have to start collecting your retirement pension.
The next question, we're getting into the legal one. So this person says, last year I was cut off from long-term disability after 1.5 years, but all the while I was on CPP disability. I was forced to attempt to go back part-time and failed. I'm now suing my insurance company. In your experience, how much does CPP disability affect the probability of success, if any? My employer dropped the insurance company after the appeal was denied. Would that help my case?
With respect to dropping the insurance by the employer, no. Not unless the employer is the city of Calgary or something. Most employers don't have the type of premiums or annual premiums that'll make any insurance company look. With respect to the CPP aspect of it, yes, you being on CPP definitely assists with the legal case. What it does is, well, it should. And what's irritating about CPP as it relates to LTD is that I've got the same counsel saying, well, James, your client didn't get CPP. And I'm arguing with the two different definitions. And then when my client does get CPP, that same lawyer will say, oh, but James, it was done by an administrator who didn't really pay much attention. So at that point, I just want to jump over the table and throttle the little bugger. But anyway, yeah, I mean, having CPP reduces the technical value of the case on a short-term monthly basis because it's usually a straight dollar for dollar deduction. But what it does do is it brings in the prolonged aspect of it. And I'm not surprised that an insurance company would terminate even when the person's on CPP, but it's not normally something I see a lot of. So.
Okay, we're just trying to bring Hugh up on the screen so that if he waves his hands, we know that he wants to answer the question.
This is not really my area, but I believe in the United States, where the equivalent is the Social Security disability insurance, where an insurance company has required somebody to apply for the government benefit and then cuts them off as soon as they get it, there's been all hell has broken loose.
And that just goes because frequently, and I've been looking for a case like this, haven't come across it. The insurance companies are a little bit smarter than that. I've heard stories of sometimes where the insurance company will keep the person on benefits until they get the CPP back pay, and then it's just a coincidence, I guess, the person is no longer getting any LTD benefits after the insurance company gets the CPP back pay. Not saying there's anything nefarious going on, just saying it raises a question.
Go ahead, Hugh. We can hear you, but we can't quite see you yet.
Oh, well. So, yeah, having the CPP should make a significant difference. And the fact of having the CPP goes a long way. Number one, it reduces the insurer's responsibility in terms of money. And number two, it gives them, I would suggest, a higher burden to meet, depending on where you're at in your LTD claim, because you've already been approved based on what, on the face of it, is a more stringent definition of disability in the CPP as compared to the LTD. One thing that the insurers will sometimes do is say, well, because of the real world assessment requirement that's applied by the CPP, they will suggest, well, we don't have that same requirement in the context of interpreting our insurance contracts. There's a bit of case law going both ways on that, but my view of it is that ought to apply, that you need to apply a reasonable standard, even in the interpretation of the insurance contracts. And so I think it should make a big difference. The issue of the dropping of the insurer, I would say, is a factor only to the extent that the employer may, if you're still employed, then it could be a factor, because if the insurer is somebody that had a relationship with the employer, then that's a factor that does impact potentially the decisions of the insurer vis-a-vis the employer. But otherwise, it is not usually an issue that would be significant.
Well, by the same person saying, the long-term disability insurer cut me off due to an independent medical exam by a psychologist who said they were not an expert. The appeal was denied despite a letter of support from my specialist, who is expert. What are the chances of getting punitive damages and aggravated damages? It seems so deliberate.
Having argued probably the most significant punitive damages case in employment law in the last 25 years, the Keys and Honda case, where again, that was on behalf of an individual with ME and CFS, and the employer took steps to terminate them in a most improper way. In terms of punitive and aggravated damages, what I would say is that the Supreme Court of Canada, in the Honda case I'm talking about, and an earlier case called Fiddler, that was done out of Vancouver, that went up to the Supreme Court, it changed the scope and definition of how aggravated damages are granted. And I would separate out aggravated damages from punitive damages. First of all, aggravated damages are compensation, whereas punitive damages is like a punitive fine done through a monetary award, but it's a punitive fine based upon egregious misconduct on the part of the insurer. So aggravated damages are easier to get than punitive damages. And I would say that it's possible, but I would not bank on it, only because even if you got it, it's not likely to be a huge amount of money in most cases. Usually in Fiddler, it was $20,000. It's going to really depend on the extent of the harm and the damage done to you as a consequence of the nefarious conduct. And in the context of punitive damages, it's an even higher standard to meet. But I think to answer the question more specifically, it's really a question of ensuring that you're able to provide a suitable response to the denial and to the IME report, to the extent that you can either refute and or undermine the value of that report by looking at the totality of the medical evidence. Because the psychology report is only looking at a limited element of the claim. And so to the extent that there are other doctors or even psychiatrists or psychologists that are addressing the different elements of the claim, it's important to point out and to bring home the totality of the claim. And to the extent that the insurer continues to deny that totality of the claim, that would bolster a claim to aggravated and potentially punitive damage.
Another question is, if you never claimed disability at work, but you were eligible for it, and you never claimed as you did not know you could, and now you're laid off, wow, can you go back later with a lawyer and get them to take you on as a disability case? Go for it.
Essentially, the answer is probably not, but there's a big proviso. If you got laid off strictly because of a standard layoff, and there were a number of people laid off, and you could still technically do the job, then the answer is no, because at the time you were laid off, you weren't disabled. However, there has been situations that I've taken on in which the person can't do the job, gets written up, gets called in, gets fired, and all the time there's medical support for the person's claim, but the person just didn't apply until after they got terminated. So in that situation, I would say, yes, you can apply as long as you are able to backdate the disability to a good, the main reason why you were terminated, and B, to have it start when you were still under coverage. So based on the way it was worded, I'm leaning towards a no because of the layoff. But if he was the only one laid off, then there perhaps may be a possibility that he was laid off because of his work performance, which then opens up the door for the disability claim. So that one's a maybe, maybe not.
I guess I have a follow-up question because people have, many of my patients have been in this position where they go on disability, they're getting paid, and now the company is threatening to lay them off. And I think, Hugh, you addressed it a little bit, but is that kosher or not kosher?
Well, it depends for the termination. If there's a legitimate business purpose, like they're restructuring and they're closing down the office and there's no longer a position to be had, that can be a justifiable termination. As a general rule, there's a requirement to keep a position open for somebody who's on a disability leave of absence, to keep their position open for them. But that's not to say that in certain circumstances it's not appropriate for the employer who is terminating somebody because of the fundamental change in the nature of the workplace. In terms of answering the broader question, like I said, the key is, when does the person become disabled? And to the extent the person can be deemed disabled during the period of time that they were working, or alternatively during a reasonable notice period, then either the insurer and or the employer may have responsibility in those circumstances. The challenge then becomes the limitation period, both within the policy of insurance itself, which usually requires it to apply within, say, 60 days and put the insurer on notice. And then more broadly speaking, in terms of Limitations Act in the province, in Ontario, for example, you have to bring a claim within 2 years after which you know of or discovered the liability. So to the extent you're beyond that, there's an issue. Now with disability benefits, there's been some argument about the issue of a rolling limitation period, because each month is to some extent considered a new and renewed element of the action in some instances. So there's been cases previously that have looked at and said, well, even if I may not be able to claim and go back for the back pay, then there's an ongoing rolling limitation, and I should be able to claim going forward on a monthly basis if I can demonstrate the disability during a period of coverage.
Okay, a question from in-house, and this is another one that comes up a lot in my practice. After a client is approved for any occupation LTD benefits, how often does the insurer reevaluate their eligibility or ask for medical updates? And I'll just say, is there any recourse if updates are being asked for frequently?
If I can step into that one, first off, what I would say is that it depends on the insurance company, really. And what I would say is that the insurer has the clear right to adjudicate and manage the claim, including to conduct independent medical examinations, to conduct rehab assessments, and things of that sort. They have to do it reasonably. I always approach these things by saying that to the extent that there's a recommendation to implement a rehab proposal or something like that, then I'm going to require that the medical treating practitioners sign off on that before it's implemented. So although the assessment may be capable to be done, that the rehab proposal, the return to work plan, would need to be signed off on by the doctor before I would typically allow the individual to be able to be sent back. But in terms of harassment and the use of these measures as a means of harassment, it's a fine line. I mean, they have the ability to do it to the extent that they're doing it on a consistent and unreasonable way every few weeks or something like that. That might well give rise to a claim of aggravated damages and breach of the policy in terms of the manner of treatment. But and the usual practice is, they're going to do it every 6 months or once a year or once every couple of years, depending. And as the person gets older and gets put on, particularly after 50 or 55, you know, they tend to get put onto a different list, which makes it less frequent, maybe once a year. But again, it depends on each case. And then once they appoint a new adjudicator for the file, because the adjudicators are constantly rolling over as well, it's not uncommon that a new adjudicator will then step in and say, well, I'm going to take a new fresh look at this and see if we can't reassess and or cut some costs for the company by determining if this is a claim we can effectively cut.
Okay. James, did you want to add anything to that?
Well, I echo Hugh's comment. The one thing I noticed was that as long as they're not coming quicker than about every 2 to 3 months, because I argued that very situation in front of a judge at a pretrial conference in Saskatoon about a decade ago. And the judge basically said, Mr. Ludwar, as long as your client is receiving benefits from the insurance company, she's effectively working for the insurance company. All right. Now, that judge is no longer on the bench, but essentially, I guess the only way to kind of stop it is and I've gotten medical reports from the family doctor saying, look, these constant IMEs, the last 3 haven't shown any significant changes. And yet every time you do these IMEs, my client's in the office the very next day, he or she is wrecked for the next 2 months or month. And these are medically contraindicated. And that gives at least it should give some pause for the insurance company to rethink their IME process.
Thank you. So there's one question which I'll paraphrase, because I think a lot of people are in this position as well, especially with MECFS where they've been ill most of their life. And I've just lost the question here. As a young person under 30 with ME and FM, I have been trying to attend university unsuccessfully and have not been employed. I've been rejected by AISH once, disability tax credit twice, and do not qualify for CPP-D or insurance. What options are there for someone in my situation, and how can I improve my chances for being approved for programs? Maybe, John, I'll get you to answer that one.
Yeah. How many times did they say they'd been turned down by AISH?
Once.
Once. Dale didn't mention this, but if you get turned down by AISH and then turned down by the appeal panel, AISH will reopen the file if you submit new evidence within a year. And that might be an option.
Okay.
The only other thing I can suggest is other than Alberta Works, is to reapply for AISH and hope for a better outcome.
Okay.
Maybe get
So
help.
just keep trying.
Maybe
basically.
get some help.
Okay. Here's another one. What if a person is disabled from his own job, but the employer agrees to accommodate the disability at the same salary, and the claimant is scared he will be fired after a year or so, giving some reason to terminate the employment and paying severance? The person ends up without a job, without insurance, and no new employer willing to accommodate. So this is also a fairly common situation.
And it's really the heart of what I was trying to talk about in my talk. I think the essence of what I would say about it, if I may, is that, you know, to the extent that the employer is willing to accommodate, and to the extent that the individual may be able to attempt to return to work, that I think it's in the interests of the person to do so, because doing so will do several things. Number one, it will enable the party to return to work at a higher income than the insurance benefits will provide. Number two, to the extent that they're terminated from employment, they potentially then are entitled, and a severance and notice period may be triggered by the wrongful termination. And at the same time, if they're disabled indeed while they were working, and if it can be drawn back that they were in fact disabled, and that's indeed the reason why they were terminated despite their best efforts, then that actually would strengthen, in my view, a claim to both insurance and to CPP, ultimately disability pension benefits. So I think for those reasons, you know, the challenge I think is how you do it. And what I do in these kinds of cases, I make sure that there's a clear proviso within any rehab or return to work plan that there's going to be a doctor with ongoing monitoring and oversight capacity, the treating family doctor or specialist who needs to sign off on the return to work program and the terms of it. and is able to adjust it and modify it as needed or as appropriate. And at the same time, to the extent the person becomes disabled and can't continue on for a period of time, then they would then have the ability to seek the LTD benefits again. So, and I think their claim is to some extent strengthened in that instance because they've made the effort to return.
Okay.
Yeah. Essentially, what I do with my clients in that situation is, as long as a doctor is prepared to sign off on it, I tell them, go ahead and try. I've had clients not even make it out of the parking lot. They drive in the parking lot and whatever reason can't do it. The key is get to the doctor. From a legal perspective, it's always better to try something and fail at it than not to try at all. And that just builds up the whole credibility of the case.
We're going to actually end it there. There's a few more questions, but they're not maybe just as directly on topic. There's a bunch of questions about how to get the phone numbers for various of the presenters. And in the original notice of this event, there were the websites for everybody and online for the recording when it is posted. When do you think that'll be, Mike?
Next week.
Okay, Mike's saying in about a week, which is quite fast. In that recording, there's going to be information on everybody's contact, and in the case of Asian CPP, the website addresses so that people can go to them. Well, thank you very much to all the speakers and to the audience for your participation. We'll leave it there.